Hello and welcome to Newsclick. Now, a couple of weeks ago, the Indian Patent Office released a new set of guidelines on the examination of computer-related inventions. These guidelines have the effect of enlarging the scope of patents for software, thereby restricting the scope of innovation for programmers. To discuss the issue of software patenting and the effects this can have on our society, as well as the very specific guidelines issued by the IPO, we're joined by Venkatesh Hariharan, outreach lead for the Open Invention Network and a member of the Ispirits experts group on software patents. Hi Venki and welcome to Newsclick. Now, the Indian Parliament has specifically chosen to exclude software from the scope of patentability. Why should software be treated differently to other products which normally get far greater IP protection?
The reason is that software is an applied form of mathematics, and if you look at software, it is already protected by copyrights. So typically most inventions are not protected by copyright. So here you have a case where software is protected by trade secrets, it's protected by copyrights, and also in some jurisdictions with software patents.
Right.
So the challenge with software patents is that in practical terms it doesn't work. The reason is that software patents and patents are basically supposed to be a form of intellectual property, but a property doesn't really work if you cannot really set the boundaries of this particular property. If I do a title search for land, I can say that east, west, north, south, these are the other properties that are adjacent to my property. But in the case of software, it's a very abstract phenomena. It's basically an applied form of logic. So if you do not patent mathematics, if you do not patent logic, how can you patent software? And there are also practical implications of this, because it's very difficult for a software developer to figure out what part of logic has been patented. Today if I have to sit down and do a e-commerce website and launch it in the US. In the US there are some close to 16,000 patents on online shopping, e-commerce. So there is absolutely no way that a software developer will be able to figure out which of these 15,000 patents am I violating.
Now, you've laid out some of the reasons why we should not actually consider patenting software. But there is actually a big MNC lobby in particular which is pushing for enhanced protections on patents on software. Now, are there any valid reasons to your mind why India should consider enhancing IP protections for software? Is there any force behind these arguments that we see from MNC companies?
So I would say that whenever these arguments are being made, I think we have to be very careful about how we bring that into our jurisdiction. So for example, if you look at say the ecological footprint of an American, it said that it takes almost 40 acres of land to sustain the lifestyle of one average American.
Right.
Now if you import that kind of a principle or a philosophy wholesale into India, we'll have to start colonizing the Indian Ocean.
Right.
So whenever people from other jurisdictions come and say that this is what is best for India, we have to apply our own yardsticks and say that will it really be of benefit to our context. So we have to look at the fact that we are a heavily services based software economy. We also have to look at the fact that in the recent past we have seen the emergence of a very vibrant software product ecosystem. Then we also have to look at what is happening around the world, and there are studies which now show that because of software patents and because of the ways in which software patent trolls and patent owning entities are asserting software patents, the amount of venture capital funding has actually gone down. There are studies which show that the litigation around software patents and business method patents is actually the highest among all kinds of litigation, and which is because of the reason which I mentioned earlier, that software, it's very difficult to identify boundaries in software.
Right. But one of the arguments posed against this is that if the patent office has actually scrutinized applications properly and only granted patents for things that are clearly within the scope of patentable subject matter, you wouldn't face these problems with patent trolls, so on and so forth. Do you buy that argument?
So I think the question is first of all is whether software itself is patentable subject matter or not. So that's the fundamental thing. Everything else follows from that. And I think clearly, to my mind, software is not patentable subject matter, because you write software, it's an applied form of logic. So it should not be patented. It's something So the here's the challenge. If I'm a software developer, and it's very difficult for me to figure out what kind of software is patented. And the thing is, if I copyright treats software in a very different way. So let's say, you write some code and I write some code, and we write something very similar. You and I may write poetry, or you and I may write code, and it might be very similar, but we have arrived at it independently. So in copyright, I can say that I have arrived at this independently, therefore it is mine, even though it sounds very similar to yours. But with patents, the problem is that you own the patent, and even if I have arrived at it without reading, or without willfully copying you, then I'm still liable for infringement.
So what is the, do you think that the stance that you are taking regarding the patentability of software per se, is this an attitude that is prevalent generally amongst the industry, both in India and in countries abroad such as the US?
So the open source community has been, and the free software communities have been very vocal in their opposition of software patents. Because as far as the open source community goes, and the free software community goes, our whole idea and our whole dream is that we want to create software and add to the knowledge commons, and so we think of software as a public good. So when we write software, our dream is that millions and millions of people should be able to use it without any hindrance or barrier to access. Whereas software patents basically monopolize and add control to these particular ideas. So Amazon owns one-click shopping, etc., etc. So I think open source philosophy is that it gives power to the users, whereas the principle of software patent is that it concentrates a state granted monopoly into the hands of a corporation or an individual. So I think these are two fairly antithetical viewpoints. So the open source community worldwide is against software patents. The New Zealand software industry, almost 94% of them voted against software patents, and they put pressure on the New Zealand Parliament to ensure that software patents are not allowed in New Zealand. And similarly, there are other countries. Europe has a middle of the road kind of an approach. So the US is actually a particularly bad example to give, because there are historical reasons for why the US Patent Office started granting software patents. And I think there are many people who are vocal about their criticism of the US Patent Office.
Now, this was actually something that you just briefly touched upon. You spoke about how software patents create monopolies in the hands of certain big companies, which can usually afford to file for patents, so on and so forth. Now, given the sort of abysmal record we Indians have for filing patents, for actually proceeding with this entire system, are there any strategic or broader economic implications also of allowing software patents in India? What does it mean for our economy, for our strategic considerations?
So if you look at the IT industry in India, I think it has clearly been the industry that has really reshaped the Indian perception of India in the global eyes. You have these, IIT graduates like Sundar Pichai at Google and at Microsoft, etc., etc., Nadella and others. So, so the thing is that here's the challenge. Today in India, in the patent office, most of the patents, almost 95% of the patents that have been filed by the MNCs. So if you look at the balance of power when it comes to software patents, they are the ones who have been patenting software for years and years and years, and when they come in and start filing patents for things as trivial as booting up a computer from a USB stick, which any BTech student can pretty much write, or things like how do you kind of the interrelationship of different cells in a spreadsheet. So when you have patents on those kind of fundamental thing, what will happen is that as far as software innovation goes in India, there will be more of litigation and less of innovation. Because as a software developer, what I will have to do is that if I am writing, say, some spreadsheet kind of a program on the cloud, I will have to start and go and look who has patents on spreadsheets. That discovery process is going to be a time consuming process.
And of course, as you pointed out, the scope of that patent might also not be very clear.
Yes. So the challenge with software patents is that even if I get a legal opinion, it is only a advice or a suggestion or a it's not a conclusive
So there's no surety about your business.
Exactly.
Now, the law as it currently stands in Section 3K of the Patents Act permits software patents only when combined with a hardware component and assuming that this device or innovation taken as a whole meets the standard tests of patentability, that is, its novel industrial application, so on and so forth. So, how does this new set of guidelines issued by the Patent Office actually change this interpretation of the law? You've previously been quoted as saying that this change that has been made in the guidelines is essentially an expansion of the scope of software patents through the back door. Why do you say this?
So we were involved with the amendment, and we were involved with talking to people in Parliament, and clearly when the amendment was passed,
You're referring to the 2005 amendment?
2005
amendment,
yeah,
yes.
the Patent Amendment
Yeah.
2005.
Yeah.
So that so the clear intent there was that the technical effects of software should be outside the purview of patentability. So if you look at Section 3 of the Patent Act, it basically deals with subjects that are outside the purview of patentability, and Section 3K deals with software, and it says that mathematical methods, software algorithms per se are not patentable. So this per se, I think, has become a bone of contention and a route for creative interpretation of the law. So if you look at the intent of the Parliament, it was very clear that technical effects of software and software in itself should not be patentable subject matter.
Right.
But if you look at if you read the computer related inventions guidelines, that brings in the effect of technical effects of software being patentable.
Right.
So what will happen is that the patent examiners in the Indian Patent Office will use the guidelines and then approve software patents, and then that will lead to a flood of software patents across India. And this could also lead to a lot of uncertainty, because it is clear that at some point in time, if software patents are granted, it will be taken to courts, and the courts will have to then obviously what the court will do is look at what was the will of the Parliament, what was the intent of the Parliament, and do the guidelines accurately represent the intent of the Parliament.
Yeah, absolutely. So what scope is there now for the guidelines to be changed? Because I understand the Patent Office actually did have a consultative process. Whether those comments received from the public were actually considered or not is a separate matter. Yeah. But given that these guidelines do not constitute statute, they are not rules, these are just an executive decision made by the Patent Office. So how do you see things changing, or what plans do you and the free software community in India have to put pressure on the Indian Patent Office in this regard?
So there are two interpretations. One is that this is something that has emerged because of lack of understanding of what is a software patent, and the understanding of the rules itself. And that could be the case, because in India we do not really have a long history of examining patents around software. So it could be a misinterpretation, and which is the best case scenario. Right. The worst case scenario is that this has been motivated by the MNCs and the political lobbies which have been pushing for software patenting in India. And of course there's a lot of lawyers who have been so whenever there have been these consultations, we have found that lots of lawyers come in and say this will help innovation, and obviously the thing is that
it's
for them,
the legal fraternity basically.
For them it's wonderful, because something that is so ambiguous as a software patent is a fertile ground for litigation.
Right.
It said that almost 37% of all litigation around patents in the US is because of software patents and business method patents. Right. So it's a fantastic, if I was a lawyer, I would be salivating at the possibility of software patent litigation, because there's just no way that you can figure out what this particular patent means. I mean, anybody who's seen a software patent and read it and understood it, I think that guy is either a genius or an idiot. So basically, I've seen that most of the roundtable discussions and the consultations have been dominated by the lawyers. And frankly, every time a lawyer uses the word innovation, I mentally cut and paste and replace it with the word litigation.
Well, I think that's a good note to end today's interview on. Thank you, Venki,
Thank
for
you.
joining us. And this is an issue we will continue to follow as we see what happens with the Indian Patent Office. Thank you for joining us on Newsclick. Do join us again later.